And lawyers, guns, and money.
Boom. Okay, now this takes us to the week of September 21st, depending on when you listen to this. The part of the story that we left out at some point, immediately after the crash happened, the LA County Sheriff's Department, or the sheriff over there, spoke to Vanessa Bryant and said, I'm going to personally make a personal guarantee that this crash scene will not be tampered with. There will be no photographs taken of any remains, and we're going to treat this very sensitively. So he apparently made some allegedly, of course, personal assurances to Vanessa. Vanessa was really taken and really happy with that conversation, and they went their separate ways. The next time we hear of anything about this crash site or photos being taken, a local bartender in California, overhears a sheriff's deputy talking to a female patron at the bar and basically kind of bragging, hey, look at these pictures I took or that I have from the Kobe crash site, and showing off the pictures. We probably would never found out about it, but for a good Samaritan bartender who filed a complaint and made this thing public. And the allegation is that the police never told Vanessa or any of the survivors, the surviving family members, that these photographs were taken, that Vanessa and everybody else just found out about it with this kind of whistleblower bartender. So there was a claim filed against the LA County Sheriff's Department back in May, not an official lawsuit, but kind of a heads up that a claim was going to be filed. And now today, the week of September 21st, we have that lawsuit filed. So in the lawsuit, essentially, Dan, I'm going to turn it over to you for your expert legal analysis. But the claim is essentially saying, for better or for worse, it's an invasion of privacy claim. You made a promise, you made an assurance that something wasn't going to happen, and guess what? It did, and it's harmed me. So they're seeking punitive damages among compensatory damages. But it's really a kind of going at your throat. It's kind of a, and people are quote, dropping in my replies, telling Vanessa to go get him, and that it's disgusting, which, Dan, if it's true, it is disgusting. So Dan, you break it down. I know, we talked offline, but give me your thoughts overall on your impressions of this.
Well, I mean, I have a lot of thoughts about this. Number one, this is Los Angeles County. Vanessa Bryant is suing the Los Angeles County and Los Angeles County Sheriff's Office. So she's going to be asking a jury to basically award damages against themselves because the damages that are paid by the county are really, funded by taxpayer money. So on one level, that's an optic that I think of, that it might be somewhat of an uphill battle. But in reality, I think there's a lot of enmity against law enforcement and against this particular sheriff's office. So I don't think the jury pool will be contaminated against Vanessa Bryant. I think quite the opposite. The sympathies and the leanings are going to be towards Vanessa and Kobe Bryant and against the sheriff's office. But when you mentioned the bartender, the first thing that comes to mind, I mean, he was basically the whistleblower. If this were like a qui tam lawsuit against the federal government, the bartender would be able to get a percentage of the recovery for blowing the whistle on government waste or government, corruption. In this case, the bartender, he'll be lucky to get a tip. Much less a qui tam recovery. But I think what's lost in the analysis, or at least the reporting of this lawsuit against the LA County Sheriff, is that it's not quite the slam dunk that I think most people would, intuitively think it is, because we all would agree that the taking of these photos showing the bodies and the crash scene, and then displaying those photos, to friends or in public establishments, is so far beyond the pale that no one can question that there should be liability here. But the tortfeasor, the primary tortfeasor in this case, isn't.
But let's talk about what the tort is. First of all, it's invasion of privacy, right? I mean, that's, right. We don't want to bury that. I mean, there is an actionable tort for invading someone's privacy in a harmful and malicious way.
No question, but okay, so invasion of privacy, negligent infliction of emotional distress, negligent supervision and hiring, all these torts or all these causes of action, I think you can really make a strong case against the individual sheriff's deputies who committed these torts. who invaded, the privacy and caused all this emotional distress. But they're not the deep pockets, right? I don't even know if they've been sued. I've yet to see a copy of the complaint, none of the stories. And by the way, that's a pet peeve of mine. TMZ has received a copy of the complaint, or Daily News has, learned, we've seen a copy of the complaint. Nobody ever links to it. That is like one of my pet peeves. That if you're going to report on the story and you're going to break the news of a lawsuit, why don't you just provide a link to the complaint? So on this first day of the reporting around Vanessa Bryant's new lawsuit, I have yet to see a copy of the complaint. But what I have learned from the reporting is that the defendants appear to be the entities: Los Angeles County, the Los Angeles County Sheriff's Office, and the Sheriff, I think his name's Alex Villanueva. And the one issue, or the one barrier that just sticks out for me, is sovereign immunity. And, I understand you sue the sheriff's deputies directly. They're the ones who committed the tort. Their implementation of the, their low level actions at the staff or operational level definitely would give rise to an actionable claim. But when you seek to impose municipal liability on the sheriff in his official capacity or the sheriff's office, you're then getting into issues, or potentially issues, of sovereign immunity. And California has a state level immunity statute for governmental employees under Section 820.2 of the California Government Code, which basically immunizes public officials from damages and claims arising out of their discretionary policy decisions. And in weighing whether there's immunity or not, there are two types of, governmental actions. There's policy making, and then there are operational actions implementing that policy. And depending upon which level of behavior applies, could decide the immunity issue. And I think the theory of Vanessa's case is that Sheriff Villanueva is liable not because he took the photos or invaded invaded her privacy, but it's that he didn't conduct any formal inquiry or investigation, and simply told the officers or the sheriff's deputies that if they deleted the photos, nothing would happen. And then didn't do any follow-up to verify that or inspect the phones. And her theory seems to be that he's responsible on a negligent supervision or negligent hiring claim as sort of a municipal defendant. And for that might rise to the level of being a policy decision rather than an operational decision. So these are very high stakes. I don't think there's, you can be half, it's not half operational or half discretionary. I think that this falls into the realm, I think, potentially of being a discretionary policy decision. And if his decision not to convene an investigation falls into that category, he's immunized from liability under this state law. There is an exception to it. I think negligent supervision and negligent hiring are an exception to the public official immunity, but I think that's the issue that stands out as the most important one in the lawsuit.
Yeah, I mean, I don't want to pretend I'm so familiar with Los Angeles politics, Dan and I being from the East Coast. But, I'm just you do a quick Google search of Alex Villanueva, there's people calling for his job left and right, votes of no confidence that are being thrown out. He's taken a lot of heat, and obviously it looks like he's the first sheriff's deputy, Hispanic speaking, of LA County, I think in like 100 years. So obviously there's some, historical precedence to his hiring and his position. But when you're dealing with someone like Vanessa Bryant, it doesn't matter who you are. If you're not handling this properly, you're going to get some heat for it. So I think, Dan, I want to make sure we hit this. It's a topic that, in field of law that I practice, defense work, a lot of it's investigative work. If I know that a photograph exists and I can't find it for some reason, but I know that it exists and you're not turning it over in discovery, I'm going to keep asking for it. And if you don't provide it to me, and you don't provide me an excuse of where it is in an affidavit of search, more often than not, I mean, at least I'm angling to get what's called a spoliation charge, that the photograph or whatever it is that I'm looking for is not there because you made it not there, right? Because you deleted it. So the allegation that's basically out there against Alex Villanueva and the, LA County Sheriff's Department, is that these photos are not there because Alex Villanueva basically said, allegedly, of course, delete the photos and you won't get in trouble. So guess what, Dan? It's really hard to prove invasion of privacy that you impermissibly showed these photographs at a bar if the photographs don't exist anymore. We can talk about TMZ's good reporting, but TMZ is also sometimes in the news for bad reporting, right? They put pictures out that we don't want to see, sensitive materials that we don't want to see. I have a feeling, this is just my hunch, and don't quote me on this, but I mean, if the photos were really out, right, and they weren't truly deleted, knowing TMZ, and TMZ understanding the newsworthiness of, this story, I imagine the photographs would be out. So now, Dan, we're in a world, again,
they wouldn't publish those photos. TMZ, you could accuse them of bad taste, and they'd be willing to do almost anything, as any news organization in this competitive landscape would do for a buck. But I think showing the bodies following a plane crash is probably a line that wouldn't be crossed.
I'm in agreement, but what we might see, Dan, and this is just to our point, and I've seen this a couple of times. Hey, we have the photographs, we're in possession of them, we're not disclosing them. I think TMZ would have gotten a hold of them one way or the other. Whether or not they disclose them, people have their own opinions about TMZ. So now back to this particular lawsuit, the reason we wanted to do this podcast. If you don't have the photographs, which is my God, right? The photographs don't exist. Doesn't Vanessa have and listen, we'll talk about the individual deputies, whoever it is. I mean, doesn't she have a huge edge? I mean, the photographs aren't there, right? Isn't that the whole case? Isn't that a spoliation charge just waiting to happen? Just pressing that big red button?
I mean, I don't know that the photographs don't exist. I think there should be a stipulation that the photographs existed. I think Sheriff Villanueva.
And you don't think he would have any liability if that occurred, that if they go on record and they say we deleted them because Alex Villanueva told us to?
Well, there were some sanctions that would be appropriate for that. For example, if you didn't produce them in discovery, now they haven't been discovered yet. It's possible that those photos can be retrieved from cell phones. That there may be some manifestation of them somewhere that the sheriff's office and the individual defendants, if there are individual defendants, would be able to produce that, or at least admit to it in a request for admission or some type of document. But the consequences associated with spoiling the evidence or exfoliating the evidence usually comes down to the judge will strike your defenses, not allow you to present a certain defense because you destroyed the evidence. So I think it doesn't amplify the damages, so to speak. What it does do is give the court significant leeway and discretion in imposing a procedural sanction against the defendant who exfoliated the evidence that would make it more difficult to defend the case.
I have another one for you, Dan, because this is I did municipal work briefly over at Nassau County Attorney.
Yeah, for a guy in his early 30s, you're like a true Renaissance man. You've worked for the Giants, you've done insurance work, you've done municipal work. That's pretty impressive in this, in relatively the front nine of your legal career. I'm quite impressed.
We'll say the front seven of my legal career, but who is counting?
Well, maybe the front, you're on the fourth hole.
Yeah, something like that.
Okay.
No, but I wanted to at least bring it up. I mean, Dan, I remember that
It's a par five.
Par five. It's a par. We can have fun with golf terms, okay. But I mean, I'm gonna probably mess up the actual term. Some municipal lawyer somewhere, on the millions of listeners of this podcast is gonna call me out for it. But as a governmental actor, you have immunity for acts that occurred that are in furtherance of your job that you take within that role.
Mm-hmm. Great point.
I don't know if deleting. Hey guys, delete the photos so you don't get in trouble with your job. I mean, I don't really know if that's in furtherance of any type of official duty, right? If anything, that's kind of harmful to your job, right? If there's some type of investigation, it seems like he was almost giving them that olive branch as a kind of a favor. It has nothing to do with his duties as sheriff. It seems like it's actually in contravention to his job.
Well, I would say doing your job badly doesn't necessarily place it outside the scope of your employment. I think when we look at
how would that be in furtherance of the job? Telling people to.
I think you might be conflating the two.
There is the the intentional tort business that I'm kind of graying in between, but I just governmental function immunity?
I think he made a really poor policy decision here of deciding that his way or the policy that he was implementing was, instead of doing a true investigation, he would try to convince the officers to undo the harm, which is a really despicable decision.
I'm not sure the harm is undone. I'm not.
Yeah,
I'm
not. Definitely not. But I think he was acting within the scope of his employment. But I would say that the sheriff's deputies were clearly acting within the scope of their employment when they took these photos. But when they released them and disseminated them at the bar, they were certainly outside the scope of their employment. And on that measure, maybe the sheriff's office can separate, or at least distance themselves from the officers' actions off duty that were not within the scope of their employment. And in that case, maybe the respondeat superior chain is broken.
So I'm gonna push back on you, Dan. This is an honest question.
This is a great debate. I mean, these are fascinating issues, all without the benefit of the complaint.
I mean it though. In what world, right? I haven't, in my Renaissance world, Dan, of my Par 5 or however analogy, I've never worked as a cop. But in what world would a sheriff's deputy, who is not a medical examiner, right? They're not doing the autopsy report. Why would they need to have the photos? And Dan, I'll go one step further. If the photos can be so, hey, don't ask any questions. We're going to delete the photos right away. Just give us your phone and we'll delete them. That tells me that those photos were not essential to their job. If we're just going to delete them, right? It's another argument if you say, these photos were really important and we need to save them and document them. So you just have to tell us which photos are out there. It seems like they very much took those outside the scope of their employment, in which case, then you may be looking at more liability. If you could just, again, we're on the assumption that Villeneuve actually told them to delete them. I think that's almost, pretty strong evidence that this was not part of their job description. If they could be so easily deleted, right? And the medical examiner who was preparing the autopsy report, I'm sure, as this was going on, if they didn't have those photos, right, and they weren't fully documented, they weren't date stamped, whatever the equivalent of that is, I think that's pretty strong evidence that these were not taken in the scope of employment, and they were just taken for, a memento. I don't know what kind of sick person would need a photograph of a crash site, but that's, I think, what happened.
Yeah, Dan, I wouldn't give up the hope or eliminate the possibility that you'll be able to, work as a cop. I think you could play a cop. I could see you on, Law and Order Special Victims Unit. You definitely have the hair for it. So, if you ever have an opportunity to go to a casting call, I could definitely see you as the young, district attorney or assistant district attorney who's going to work with the police department and prosecuting.
And this is what we're doing right now. We're auditioning. And by the way, it's a quick shout out for those that haven't watched our show on YouTube. You could see Dan's beautiful Capitals shirt that he almost put on, decided not to put on.
Yeah, it didn't make it. It didn't make it. Here's my Capitals shirt.
And
there's a story behind this shirt, Dan.
Nobody asked you about the story behind the Capitol shirt. Just so we're keeping score here.
I want to name drop. It was the day that I met Ted. I had a meeting with Ted Leonsis at the Capital One Arena.
That is the owner of the Capitals and the Wizards. The Wizard.
Yep. He invited me into a meeting, and it was like one of the greatest days that I've ever had in terms of business meetings. He's one of the most fascinating individuals and a great guy. And that was a memorable day. And I bought the T-shirt. He didn't give it to me for free. I actually went to the souvenir store at the Capital One Arena, which is now like right next to a real sports book at the Capital One Arena, and I bought the T-shirt. So anyway, we digress.
Well, Dan, I'm just going to I want the judge to note my objection on relevancy grounds, but we're talking about Kobe Bryant here. We can't be talking about the Washington Wizards and the Washington Capitals. I digress.
Or Mystics.
Or the Mystics. True.
Mm-hmm.
So importantly, let's get kind of back to brass tacks. Let's go along with this assumption that these photographs were not taken in the scope of their employment, right? And we've had some admissions, some stipulating that these photographs were not taken in the scope of employment. Do you think that the sheriff's deputies, maybe even though that they're a lesser pocket, do you think that they have culpability here?
Oh, they have culpability, if it's within the scope of their employment, it would certainly be considered not something for which they should get, statutory immunity, because it's not, a policy or discretionary decision. It's a operational, low-level staff action. So if it's in the scope of their employment, they've got no immunity defense. If it's outside the scope of their employment, it's still a tort. It's still invasion of privacy. It doesn't matter. This is not a Section 1983 case where being under color of state law is one of the elements of the cause of action. This is a private tort. And the tort is committed by these sheriff's deputies, not just because they're sheriff's deputies, but because they're individuals who committed this tortious cause of action. Once you strip, or at least if you bring this outside of the realm of Section 1983, the federal civil rights statute, it's just, you know, within the scope, outside the scope, the color of state law is irrelevant. So they would be culpable whether they acted within the scope or outside the scope of their responsibilities. But the sheriff of Villanueva brought those activities within the scope of his employment by virtue of his policy determination to deal with the investigation or to not investigate these actions. So it became.
I'm not sure. I'm still not sure. I just want to play devil's advocate for a second. I'm not sure that that's within the scope of his employment. Because Dan, let's say we'll pretend that I'm the.
Well, it's not a scope of employment, and scope of employment is what the individual deputies did. For Villanueva, for the sheriff, the dichotomy here is this a policy-making discretionary action or decision, or is it an operational type implementation of policy, or is it neither? So,
I mean, listen,
whether he gets immunity turns on how you categorize.
But let me ask you this, because you seem to be well versed in.
No, I went on Westlaw for like 2 hours.
Stop telling people the magic. You are the guru. Okay, you knew this. You were born with this innate knowledge. You learned it by osmosis, by putting your hands on plaques, and then you knew it.
I know how to spot issues, and you know how to spot issues too. And you spot the issue, and then you try to gain a mastery over the subject matter by trying to do extensive research around it. And that's what I did for this episode.
So let me ask you this. If there's a situation where Alex Villanueva basically said, these guys are my friends, I don't want to get them in trouble, even though these photographs might be able to help the investigation and help the coroner and help the medical examiner, they're my friends, I don't want to get them in trouble, so just delete them, no big deal. And he kind of said that to him off the record. They were at the bar. You know, my wife and I have been watching Brooklyn Nine-Nine recently. They're at the bar. He just kind of tells them that offhand, don't worry about it, we'll delete them, it has nothing to do with the job, no one will ever find out about that. Now at that stage, which seems to be kind of reasonable, I could see that potentially happening. Yeah. Is that somehow now get Villanueva back in this lawsuit, or is he still immune, do you think?
What you just described as a hypothetical, I'll put it to you this way, it would be a plaintiff's lawyer's fantasy if that were the real set of facts.
I'm trying to give Vanessa a bone here. I'm trying to give us
it would be a directed verdict for the plaintiffs based on Sheriff Villanueva's negligent supervision and or hiring, mainly supervision. I mean, this is clearly what you're describing here. If he did this inadequate inquiry and basically said, just delete them off your phone, and then there was no follow-up, no inquiry, no confirmation by checking the phones, I would say that that's a textbook case of negligent supervision, which falls outside the scope of the immunity statute. So for that type of hypothetical, he would undoubtedly 99.9% be liable.
See, no one can watch me on the Zoom, but I'm making a little road with my hand. That is the path to victory to Vanessa. So I think to kind of recap, because we've gone kind of deep in the weeds in it, but I think it's important to note Vanessa did not, again, she's not suing the manufacturers. Maybe they amend them later, but she's very much going after these helicopter companies, hundreds of millions of dollars. They obviously can't support that. So helicopter companies probably going out of business. It looks like from the nature of this lawsuit, it's designed to get people to lose their jobs, be it the sheriff's deputy, or if it's all the way at the top, Alex Villanueva, the county sheriff. So, again, as an LA County juror, you're watching this. It's all in the news. I watched this great documentary on the, it's going to bother me now. But the Casey Lee Anthony case down in Florida, the jurors were very much following every aspect of that case and following her, obviously, in a negative light. Very different case, and I recommend everybody watch this documentary on Hulu. It's excellent examination of a trial down in Florida. We might disagree on this. I think that LA County jurors, there are some, and I'm seeing people from Los Angeles, that are getting, that might get turned off by someone that's being extra litigious. I think, Vanessa's rating is a Q rating, whatever you want to call it, was 100% around the time of Kobe's passing. But I know, because I see them in my replies, it's not that many people, but there's a handful of people that are getting turned off by the additional lawsuits, right? You got, it's terrible that your husband passed away, which the estate was worth $600 million. Now you turn around and you want to sue for hundreds of millions of dollars. You're suing the LA County sheriffs, right? There's some people that defend cops and firefighters and want to see the municipality do well. Maybe they're turned off by that. And then again, we could say it's not relevant to sports law, but it's relevant to an LA County jury. My wife and I were talking about it. You throw your mother out on the street, so again, not necessarily I feel this way, but I think it's important. You have to see the whole picture when it comes to these lawsuits. So Vanessa's obviously seeking monetary damages, right? Seeking punitive damages against LA County. So I just want people to put a pin in this. All of this is part of a picture that a jury looks at. Jury's going to look at everything about you. That's what they talk about in voir dire. They're going to talk about everything. They want to figure out what people have good relationships with their mothers. So kind of minute is that. So,
but they won't learn about this because the judge will not permit any line of inquiry. So you would have to have the expectation that.
But they're going to know about it from the reading the paper. Maybe they're going to be disqualified from having known a little bit about the case.
A year and a half from now, if this case ever goes to trial, and by the way, most of these cases settle. I would expect this case to settle. Yeah. You don't think it will go to trial, or you don't think it will settle?
I don't think it'll go to trial. There's not enough money.
I agree with you. I agree with you. Because I think the sheriff's office realizes that they committed a grievous error here, and I don't think there's any running away from their responsibility here. So this is set up, I think, to make a settlement offer in the low seven figures, no brainer, if you're LA County. However, I think Vanessa Bryant wants her pound of flesh. You or I, or the average or typical plaintiff or the administrator for the decedent's estate would take the $2-3 million settlement offer and run with it. But Vanessa Bryant, who has a net worth now of at least $600 million, she's looking to make a point. And I'm not so sure that she's willing to take a settlement offer in the low seven figures, because if she wanted that, I would think there's no chance she takes it. I think there's a chance it would be offered.
It's probably already been offered. They probably already offered the full policy limits. I mean, what do they have to lose?
Yeah. So this may go on for a while, but a year and a half from now, whenever a jury is impaneled, if a jury is ever impaneled, I don't think they're going to look back a year and a half and remember the New York Post article where Vanessa's mom was like evicted from the house. I mean, that's going to fade in our collective memories within a couple of weeks, unless there's a lot more that comes out about the relationship between Vanessa Bryant and her mother. I just think it's neither here nor there in a lawsuit that's being brought in a representative capacity. This is not Vanessa Bryant in her individual capacity. It's Vanessa Bryant as administratrix or executrix for the estate of Kobe Bryant. Although maybe she's suing in her own name in the invasion of privacy.
I think it's I don't know what the term is in California, but pecuniary damages, loss of earnings to the household. So
okay, so I retract that part of it. I think she is.
The reason I want to just put it on people's radars. I don't actually think this is necessarily going to get to this level, but at a certain point, if you're suing and you're saying you're grieving and you lost your husband and there's a lot of stuff that you can't do, you've put yourself in the middle of this lawsuit. So there can be and I've had the, we'll say, misfortune. I don't like deposing widows, but as a part of a defense attorney, in a bigger case, sometimes you have to ask those questions about how much money you're alleging is lost, right? How much is in the household? So by following the lawsuit, you've opened yourself up to the lawyer's questions. And I saw Vanessa's statement in response to her mother. She goes, I don't want any more of my personal business being aired out. So there is a defense attorney. Everyone needs an attorney on either side. Obviously, the pilot's attorney, pilot's got to have a hire an attorney to defend the case. The pilots look grasping at straws. Maybe they're leveraged in, and as crazy as it sounds that they have any leverage, is that they won't ask, if they settle the case early, they won't ask a deposition and pry into her personal life. If the thought came to my head the second I saw that statement, that's now something as a defense attorney, you'd say, wow, if they allow me to ask depositions, I'm going right into that area, which is disgusting, but I'll
tell you what, Dan. As to that point, and digging into her motivations or her behavior, I would just quote, as the legendary pharmaceutical expert and biology teacher, Walter White once famously said, tread very carefully when you go there. This is a jury pool that will be turned off if Vanessa Bryant is cast in a villainous
I have a good
or
one.
negative light.
I remember this. Now we're on this. It's a great topic. The Erin Andrews lawsuit from a couple of years back at this point. I remember that the hotel, so for those that don't remember, there's a voyeurism case that there was a peeping Tom in Erin Andrews' hotel room. And she was basically alleging that the hotel did a negligent job allowing some creep, some perv, to get the room next to her and drill a hole in the wall. And basically the guy called up and asked, what room is Erin Andrews staying in? And then
Right.
the guy got the room and drilled a hole in the wall, whatever he did.
I went to jail for that.
I don't remember. Well, you would know. But, that part of the defense, which was sickening, but again, you have to, as a defense attorney, if you're grasping at straws, they don't want to settle the case, you got to try to do something. Basically argue that Erin Andrews was asking for it, right? Because of how pretty she is. And somehow she was asking for a peeping Tom to, peep a hole in her wall and a video be taken of her. And that got the hotel chain, I remember, hit with huge money and punitive damage. I remember that was the big portion of that case. So treading lightly, Dan, and to quote, it was a great quote from Walter.
Oh man, you corrected me. Thank you so much. I was dying to get back into it. I said, tread very carefully. The actual quote from Breaking Bad is tread lightly.
I heard tread lightly. I mean, I heard.
Did I say tread lightly? Okay. Did you watch it? I've watched that series enough times. I've binge watched it several times over. I should have memorized and committed that quote to memory.
I wouldn't be surprised if you had a little Walter White in you, Dan. No, I mean it.
Well,
and I feel like, I never know where you are. You could be in South Carolina. You could be in New Mexico driving your RV around. I don't really know what you do. I just see you on once a week for the podcast. I don't know what you do the other 6 days.
I could tell you that I'm not walking around wearing my tighty-whitey white boxer briefs. So
it's because you're driving around in the RV, Dan. It's you're not walking around anywhere. You're getting the transportation.
The closest I have an SUV, but an RV, no, I'm not quite sure. So some mysteries are going to have to remain unsolved and unknown, and I prefer to have this aura of not knowing what I'm doing on my off hours. But really, you've got to tread very lightly if you're going to try to impugn the character of a grieving widow in a case that involves such a beloved figure as Kobe Bryant. If that were done at a trial,
not go well.
You'd lose the jury. You'd lose the jury.
That's a strategy to try to force an early settlement. But if that ever got to a courtroom, that's not going to go well. So Dan.